We will not let foreign judges decide the fate of our soldiers or our allies. That blunt promise from Washington is now taking the form of hard-hitting financial penalties. And it's already dividing legal scholars, human rights groups, and even some U.S. allies. But here's where it gets controversial. The same court that many countries hail as the last safeguard against war crimes is now being branded by the United States as a hostile actor that must be punished. On August 20th, 2025, the U.S. Department of State unveiled a fresh round of sanctions aimed squarely at 4 senior officials inside the International Criminal Court, ICC. The move is authorized under Executive Order 14203, a little-known but sweeping directive signed earlier this year that gives the Treasury Department the power to freeze assets and choke off financial ties to anyone the White House believes is undermining U.S. or Israeli interests through the ICC. Who exactly is on today's sanctions list? Judge Kimberly Prost, a veteran jurist from Canada who sits in the ICC's trial division. Washington singles her out for signing off on the court's formal investigation into alleged abuses by U.S. military and intelligence personnel in Afghanistan. Judge Nicolas Yan-Guillou, a French magistrate also serving in the trial division. His alleged offense: authorizing the ICC's request for arrest warrants targeting Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant. Deputy Prosecutor Nazat Shamim Khan, a Fijian lawyer who, according to the State Department, has continued to lend institutional support to the warrants against Israeli leaders since taking a senior post in the Office of the Prosecutor. Deputy Prosecutor Maim Mandiai Niang, a Senegalese prosecutor accused of the same, keeping the legal machinery humming against Israel after stepping into his current role. What happens to them now? In practical terms, every dollar, euro, or yen these 4 officials hold inside the U.S. banking system or in any account controlled by a U.S. citizen or company has just been locked down. Any American who does business with them, sends them money, or even buys them a cup of coffee risks steep civil and criminal penalties. The sanctions also extend to any company in which they own 50% or more, whether directly or through a web of shell entities. In short, the U.S. Treasury just turned their financial lives into a minefield. And this is the part most people miss. The sanctions don't merely punish the individuals. They send a chilling message to every lawyer, investigator, or clerk inside The Hague. If you touch a case Washington dislikes, your bank account could be next. But is this legal or even wise? Critics argue the U.S. is effectively trying to veto global justice by financial intimidation. Supporters counter that the ICC has no jurisdiction over Americans or Israelis because neither country has ratified the Rome Statute, the treaty that created the court. The debate is fierce, and both sides claim the moral high ground. For those who find themselves on the wrong end of today's announcement, there is a narrow escape hatch. A formal petition for removal can be emailed to OFAC reconsideration@treasury.gov. The State Department also maintains a public delisting guidance page that spells out the bureaucratic hoops petitioners must jump through. Few, however, have ever succeeded in getting off the list once high-level political winds are blowing against them. So where does this leave the rest of us? If you're an American company with contracts in The Hague, you now need to screen every new hire or partner against an ever-growing sanctions roster. If you're a human rights NGO, you may be torn between applauding accountability for alleged atrocities and fearing that U.S. pressure will gut the court's independence. And if you're simply a concerned citizen, you might be asking, should any one nation have the power to financially isolate judges whose only crime is following the evidence wherever it leads? Controversial take. Some legal scholars quietly suggest that Washington's move could backfire. pushing more countries to rally around the ICC, precisely because it looks like the underdog. Others insist the sanctions are a necessary shield against what they call lawfare, the weaponization of international law for political ends. Now it's your turn. Do these sanctions protect sovereignty, or do they sabotage global justice? Should courts answer to the law, or to the politics of the world's most powerful states? Drop your thoughts below. Let's see where the debate lands.